Members of the jury, you might as well wonder about a witness's testimony concerning what was said to have been seen if it were demonstrated that the witness was blind, what was heard if it was demonstrated that the witness was deaf. The jury might wonder whether a witness correctly interpreted what occurred or correctly recalled it if it was demonstrated that the witness was very stupid or laboring under some mental disability. Another test for you to keep in mind is a witness's demeanor, how the witness conducted himself or herself while testifying. It is commonly suggested that witnesses who are reliable accurately testify with a forthright demeanor, one that inspires confidence in their truthfulness and accuracy, and that less reliable witnesses frequently tip off that reduced liability by the aspect of their demeanor, whether it be signs of nervousness, fencing with counsel, contradicting or omissions, evasiveness, whether or not a witness has made a prior inconsistent statement prior to testifying here in court, or inconsistent statements previously inconsistent with the testimony given here in court, which may also be considered in evaluating credibility. But insofar as you find that any witness made a prior statement inconsistent with the testimony here in court, the prior inconsistent statement may be considered only in evaluating the credibility of the testimony given here in court, and not as evidence of any facts alleged in the prior statement. For example, if a witness testified in court that on a given day it rained here and previously had said that the sky had been clear, the prior statement that the sky had been clear could not be considered as evidence that the sky had, in fact, been clear, but only in considering whether the witness was credible when he testified in court that it had rained. There was also evidence that some witnesses had prior convictions for crimes, and those things may also be properly considered in evaluating the credibility of the witnesses who were shown to have committed crimes on prior occasions and any other immoral, vicious, or criminal acts. Now, another of the tests of credibility includes the inherent probability or improbability that a witness's testimony can have what has been termed the ring of truth. And conversely, testimony can be so implausible, so unlikely as to cause its reliability to be called into serious question. A test for you to take into account is the degree of corroboration, if any, of a witness's testimony. A witness, for example, could take the stand early in the trial and not be fully credited and not fully trusted by a trial jury. And later in the trial, the testimony could be reinforced by other testimony. Corroborated is the legal term applicable, either by testimony to the same effect on the part of a second witness whom the jury did trust, or by some tangible evidence, or both. And then they can thus find themselves fully crediting the testimony of the first witness when without the corroboration, without the reinforcement, the testimony might not have been fully trusted. Another test for you to keep in mind is the interest, if any, that a witness has in the outcome of these proceedings, and in effect, your verdict whether the witness is biased in favor of a party to these proceedings or hostile to a party to these proceedings, whether or not such an interest exists. And if so, what weight to give that interest is, of course, for you and you alone to determine, and the same is true of all the other tests of credibility. Another principle which a trial jury may take into account and, if appropriate, apply in evaluating credibility goes as follows. If it is found that a witness lied about a material fact during the course of his or her testimony, a juror may disregard all of the witness's testimony, employing the principle that someone who lied about one important thing can't be trusted about anything. In that context, that approach may be adopted, but an alternative approach is also permissible, and the second approach in that context is as follows. If it is found that a witness lied about a material fact, but other portions of the witness's testimony are still found credible,